this Wednesday, February the 5th at 9 a.m. or a little later. We're going to start this day with a hearing on House Bill 2099. And for the purpose of understanding this bill, I'd like for our reviser, Mr. Long, to come to the microphone. Thank you, sir.
Thank you, Mr. Chairman, members of the committee. House Bill 2099 amends one statute 12-16, 138 to authorize cities and counties to inspect private residential properties in certain circumstances. As the statute currently reads, cities and counties are prohibited from conducting interior housing inspections of private residential property without the occupant's consent. House Bill 2099 would authorize such inspections without the occupant's consent if the property owner receives governmental rental subsidies. So you're talking about subsidized housing in these circumstances. Reasonable notice of the date and time of the inspection must be given to the occupant. If the occupant objects to the inspection, then the city or county is directed to obtain an administrative search warrant for authorization to conduct the inspection. The bill also provides that the landlord may be required to conduct such inspection at the request of the city or county if code violations are reported on the property. And so this would be an exception to the general prohibition on such inspections for subsidized housing, and at the discretion of the city and county in enforcing their codes. This will go into effect on July 1st of this year, and I'd be happy to answer any questions.
Are there any questions for the reviser at this time? Representative Gardner.
Thank you, Mr. Chair. You mentioned that that there could be an inspection if there was a report of violations of code. Does it make any mention about who has to file that report, or how? Is that a legal report, or is that just a complaint from a citizen, or is there any direction about that?
So the bill provides that the city or county could conduct the inspection at any point at its discretion. It could do periodic inspections of government subsidized housing with or without a reported code violation. If there is a reported code violation, and the bill is not specific in terms of how that is reported or in what manner it's reported, but if the city or county has reported code violations, they could contact the property owner, the landlord, and request that the landlord conduct an inspection of the property because they've been reported code violations.
Thank you very much. Thank you, Mr. Chair.
Representative Pisney.
Thank you, Mr. Chair. Jason, can you help me more comprehensively define subsidized housing? Does that include like Section 8 and so forth? What does that terminology include?
I believe it would undoubtedly include Section 8 housing, but it would also pick up any housing in which the property owner receives some sort of government subsidy to subsidize the rent that is being charged for, the lease of that property. It's not defined under the statute, and perhaps the committee wants to look at a definition of that term to be more specific, but any form of subsidy for the property owner would qualify under this provision.
Mr. Chairman, a follow-up. So meaning either directly to the property owner or indirectly through the tenant?
I believe that would probably be contemplated as the bill is currently written, yes.
Thank you.
Representative Blacks.
Thank you. Thank you for your report. Would that, Jason, would that include you have a lease for a year, they fail to pay for 3 months, you get a reimbursement from, say, like DCF? Would that be defined as subsidized? It is from the government, but it's not for the duration. It's just for a short time that they may have been back on rent.
Again, the bill does not define government subsidies in any way, and so I I could make an argument that that would qualify, yes.
Thank you.
Representative Barth.
Thank you, Mr. Chair. Thanks, Jason, for the overview. I do have a question about the bill, especially around lines 10 through 12, how it's written today with a periodic interior inspection, and then it goes into for city code. Was there a reason that it was written this way versus writing it, only when there is a substantiated reported violation of a code? Because it's kind of open-ended right now in how it's written.
Which part? Because the lines 10, 11, and 12 are current law. And so that's how the current statute has been in place for, I'd have to go back and see when this was first enacted. And so the new language down on line 22 is essentially parroting what is current law, but providing for such inspections under these limited circumstances. And so it's just been the policy that it's periodic interior inspections. Certainly the committee can amend that to require some type of code violation be reported before these inspections can be done, but that's just how the current law is written.
Okay.
Anyone else? I do have a question for you, sir. Aside from this, are there any provisions for a health department if they have full evidence of a health situation, animal infestation, or something of that nature, to do this other than this ordinance? Do we have anything else that allows them to pursue an inspection?
I believe there are means for conducting inspections related to public health concerns. I would have to review those and see exactly when those would apply. This is, I believe, more for enforcement of city and county housing code provisions, potentially public health provisions, but again, I believe the county public health officer might have some authority to do inspections under that code. Again, I just have to do a little research for the committee.
Thank you. Representative Barth again.
Thanks. I did have a follow-up on that too, for the revisor. Thanks, Mr. Chair. When it goes down to line 27, where it says response to code violation complaints, is this plural going to require multiple complaints, more than one?
It could be read that way. I do not believe that is the intent of that language. I believe that is a casual plural form of complaint and not necessarily a strict legal form of complaint, but because the interpretation could be requiring multiple code violation complaints, if the committee wants to address that language, it can do so as well.
Thank you, committee, and thank you, Mr. Revisor. We'll open the hearing portion of this with proponent testimony. We have at least 6 proponent testimony, and we will hear all those testimonies, and then we'll open the panel for questions. And so I'll recognize John Alcala, 57th District Representative. If you will come to the microphone. Thank you for being here.
His spot because he has the initial introduction.
Very good, sir. We have Whitney Damon from the city of Topeka. Damon.
Thank you, Mr. Chairman and members of the committee. Whitney Dameron, city of Topeka. Appreciate the opportunity to be here. I wanted to make some introductory remarks, which is why Representative Alcala, I think, asked me to speak, and you'll see in the testimony I provided. When we requested introduction of the bill, we indicated we were talking to, what I perceive to be the stakeholders in this that we have seen in the past with similar legislation, the lending institution, bankers association, community bankers, credit unions, as well as the landlords and the realtors associations. And so since that time, we've taken some of their thoughts and tried to provide some changes to our own bill. So we'll be seeking amendments to our own bill as this process moves forward. And I can just highlight those, but then I think the people that follow me will talk about why we're here with this legislation and the challenges that we have under current law and what we're trying to address. Specific to a couple of questions that have been asked, we have suggested an amendment that this bill would apply only to the city of Topeka. So the way the bill is in front of you today, it's any city. But we would suggest the city of Topeka. Now, under Home Rule Authority, other cities could charter out, but that obviously would take a proactive step for them, and many cities may or may not want to do that. We've tried to narrow the focus to what our issue is and let others kind of speak for their own if they choose to go down this path. Second, we have added language that said this would be direct financial assistance for tenant rent. And so what we view this as is funds coming from a governmental entity, federal, state, local, to the property owner. There were concerns raised by the realtors and others. Would this apply to a property that would receive tax credits? We said, no, that's not our intent. And so they were, I think, concerned we could go down that pathway. And, you know, if you were in a TIF or a community improvement district or something like that, that could be deemed public subsidy and then fall under this act. That's not our intent at all. Then we provide a definition of direct public financial assistance to mean a financial payment or consideration from a governmental unit to subsidize rent. And so we view it as direct payment to the owner of the property, and I don't believe to the tenant. And then finally, there's a word that was omitted in our original draft. You'll see warrant at the bottom of the page. We added that, and so that's really kind of unrelated to our other discussions. It was just something that was omitted when in drafting. With that, Mr. Chair, I would turn the time back to you and Representative Alcala and others.
Thank you for that extra information, and we'll make use of it as we go.
Thank you.
Sure. And now Representative Alcala, thank you for coming to the committee.
Thank you, Mr. Chair, for allowing that. I'm going to start this off with, you'll hear, without having a lot of repeated testimony, I'm going to start this off by, I stand before you today in support of House Bill 2099. Here's one of the stories. For years, the Timberley Apartments in Topeka, Kansas have been ignored by HUD from regular timely inspections in accordance with HUD's policy for property receiving governmental rental subsidies. These properties have been scored below the federal guidelines for subsidized housing, causing them to be unsafe and inhumane. The residents of these properties have been strongly encouraged not to speak to anyone, representatives, city council people, but to come to the office of management and talk to them and let them know who they've been approached by. After a week of door knocking with the councilwoman of that district and myself, we finally got access to some of the properties. After entering several of the properties, there was a strong sewage smell. I was there. The basement had anywhere between 6 inches and 12 inches of raw sewage, almost like a pond. There was mold that went up all 4 sides of the wall, at least 2 to 4 feet, black mold. Several days after our visit, emergency responders were called to the units where 2 baby girls had been exposed to carbon dioxide. Now, for those of you that don't know, I'm going to tell you 200 parts per minute causes headaches, dizziness, or nausea after 2 or 3 hours. 400 parts per minute causes severe headaches after an hour to 2 hours, death after 3 hours. My understanding from the fire department that went in and checked the levels, the apartments were anywhere between 600 and 700 ppms. The city of Topeka immediately condemned those properties, causing those tenants to be relocated through the city. The city's efforts got them all relocated. 2 weeks ago, I received a call, maybe 3. I received a call from one of the tenants there, an elderly lady. She had no heat. She wanted to know what to do during this time because at this time in Topeka, the temperatures were in the 3 to 4 degrees. The wind chill was 40, and so we ended up taking her some floor heaters out there. We took out there probably anywhere between 10 to 15 floor heaters. That's how many units didn't have heat. This past summer, through the Salvation Army, we delivered 40 fans out there for people that had no air conditioning. And so one of the questions that you asked, Mr. Chairman, was, does the state have the agency, can they go out and do anything? Well, let me tell you, it was like playing hockey. State shot it back to HUD, HUD shot it back to the state. And so we basically know they don't go out and do properties like that. They'll go and do environmental issues. If they have 30 cars on a lot, dripping oil and antifreeze, but they don't do that. So I contacted Jerry Morant's office, who got on it real quick, through his chief of staff, who worked with us through the whole process, finally leveraged HUD to get involved, who wanted to play the CYA game. They wanted to blame the state. The state's not doing this, the state's not doing that. But the real bottom line of the story is HUD wasn't doing their job. They didn't do any inspections during a period of time. They tried to blame, they tried to say because of COVID, but it was way beyond and before the COVID time. And so finally they got in there, and they got another temporary management crew out there right now, so they're temporary fixing things, but not to the extent, those conditions are very, very unlivable. And so people are afraid, they're low to moderate income. I was at an individual's house when we did the door-to-door, and this is just kind of give you the mindset. The lady that we were visiting couldn't even spell her last name, and her last name was Stewart. So that gives you, that's kind of giving you an idea of how fearful they are, or can be persuaded to be in fear not to turn anything in. It's awful. Thank you.
Sure, and I'm sure we may come back to you when we get the rest of the testimony.
Okay.
Thank you. Next, we have Carrie Higgins, Topeka Shawnee County Homeless Task Force. Thank you. Welcome to the committee.
Thank you, Mr. Chair and committee members. My name is Carrie Higgins, and I am here as the lead for the Topeka and Shawnee County Continuum of Care in support of House Bill 2099. We believe this bill is crucial because it takes the burden off of the tenants, specifically those that are living in substandard housing that is receiving some sort of direct financial assistance. We have encountered numerous situations where a tenant is living in horrible conditions, and yet the landlord is refusing to fix or address any of those issues. The tenants feel trapped and scared to speak up for fear of retaliation from the landlord. As we get these phone calls and reports from tenants, we do work closely with our city's code compliance unit, and we will talk with the tenants and ask them if they are willing to let an inspector come in and conduct an inspection, and they are very reluctant to do so. They fear retaliation from the landlord, and so most of the time they will tell us no. This bill would allow the city of Topeka to address those housing violations without placing the burden and the risk on the tenant. It does cover multiple properties. I can go into that in a little bit more detail. It would be roughly 20 HUD-funded multifamily units or properties, roughly 26 Kansas Housing Resource Corporation LIHTC properties, which is the low-income housing credit properties, roughly 9 of Topeka Housing Authority's public housing properties, and then roughly 194 of THA's dwelling units. So that represents roughly 3,100 units that the city would have access to help ensure safe and decent housing. I cannot tell you how many times I have stood before a family with young children, a family that has raw sewage in their basement, mold halfway up their walls, a ceiling caving in, and they tell me it's okay. They tell me it's okay because they have no other options. They have no funding to move. They need subsidized housing, and the wait lists for those properties are very long. So they tell me it's okay because if I don't accept this, I will be on the street and homeless with my children. So we urge you today to pass this bill because it's not okay. It is not okay for anyone to be living in these types of conditions. And this bill would not only help protect some of our most vulnerable populations, but it would also help hold landlords accountable for safe and decent housing in our community. Thank you for the opportunity to testify, and I'm happy to answer any questions you might have.
Thank you, ma'am, and we'll get back with you. Next, we have Amanda Stanley, City Attorney for the City of Topeka. Welcome, Amanda.
Thank you, Mr. Chair. You've heard the compelling stories, and that's not what I'm going to focus on. What I'm going to focus on is some of the things that I think we hear in opposition to these types of bills to scare you into thinking, oh, well, we're going to go in without consent, that tenants aren't going to have their Fourth Amendment rights violated. And that's simply not true. So these types of periodic random inspections are really defeated at the Capitol and legislative level, and the idea that we're violating tenants' rights, when in fact we're trying to help tenants, we're trying to help their rights. The Fourth Amendment still applies regardless of this bill. What we can't do under current law is tell a landlord 4 times a year, we're going to do periodic door knocking and inspections. We're going to knock on your tenants' doors. We're going to ask their consent to come in. If they consent, we're going to inspect their apartments. If you have vacant apartments, we have the right to inspect a vacant apartment without the landlord's consent. There's nobody living there in that vacant apartment. We're going to do this on a regular basis. The tenants are going to know that we're inspecting because this is part of our process and not because they specifically complained about that apartment. But we're still going to get the tenant's consent before we go in. We're still going to, if we didn't have consent, get an administrative search warrant, which is found by a judge that you have probable cause to go in and do that. We're going to comply with the Fourth Amendment. There is nothing in this bill that violates a tenant's Fourth Amendment rights. What it does is take that burden of having to call code and say, hey, I have sewage in my basement. Please come out and inspect. Please do that away from them. And it allows us to have a regular routine program for very specific landlords. These are landlords that receive government subsidized housing. You heard about those housing with sewage in the walls or sewage on the floor, mold on the walls. That landlord was pocketing $800 a month market rent from the federal government to provide that type of housing. That's unconscionable. And they're allowed to do that because we pretend that it's about tenants' rights that we prohibit these kind of random inspections. We're not looking for broad scale inspections. We don't have the staff to do that. This is not about every landlord in Topeka. This is about people that take your tax dollars and the tax dollars of your fellow citizens and provide apartments that no one would live in at market rate rents. And so we think this is a very narrow exception to this law to allow us to get ahead of the game instead of constantly being behind. So that when tenants call and say, Rhiannon's here today, and she was telling me a story when we were going through Temperley. I mean, you know, she left with bugs on her legs crawling up, and tenants that said, please come back, don't forget me, but don't tell the landlord that it's my apartment that needs looked at. Like, that's how scared they are. These are true problems, and you talk to HUD and you sit in these meetings and HUD says, well, we find them, but it's more cost effective for them to provide this type of housing and take the money. That's not okay. Is this something the city wants to take on the city level? No, but we have an obligation to our citizens to try. And so we would ask for your help for this very narrow exception. It won't fix it. We'll never have another Temperley, but it gives us another tool to try to get a hold of the problem. It's not going to eliminate the problem, but it allows us another tool in the toolbox to try to get ahead of it. I'm happy to stand for questions at any time.
Thank you, Amanda. Now we have Christina Valdivia Alcala, Topeka City Council. Did I say that second name right?
Valdivia Alcala.
Okay.
Yes, thank you. Thank you, committee members, for taking the time to hear my testimony. My name is Christina Valdivia Alcala, and I'm the City Council District 2 representative, and the Timberley Apartments are located in my district. For over 4 years, I'm on my second term, I have tried to find a way for the city of Topeka being allowed to conduct interior inspections of Timberley Apartments. Anyone familiar with this property knows that even from the exterior view only, this apartment complex has raised longstanding concern about living conditions within. In my first term as a city council person, I received a whopping total of 4 calls from residents at Timberley that detailed stark living conditions. But once it came to try to arrange for an inspection or deal in some type of proactive manner, residents invariably stopped communication with me. So I knew that there was something bigger going on, again, from the exterior view only. Immediately into my second term, I worked with the City of Topeka's Property Maintenance Unit for an exterior review. I advised Director Chardine we needed to make it a priority to focus on Timberley. At the time, there were many exterior violations that we viewed and were cited. In March of 2024, the City of Topeka Housing Division Director started reaching out to both HUD and in Kansas City and the Kansas Housing Resource Corporation at the state about our growing concerns with Timberlea. Communication from both agencies was almost non-existent. We have an email trail. Ultimately, in the late summer of 2024, both Representative Alcala and I started going door to door to see if we could help people trust enough to let the city in for interior inspections. Shortly after that, it all blew open. Representative Alcala called me out of a meeting, and I went over there to find that infants and toddlers were being hospitalized for carbon monoxide poisoning, the raw sewage that you have heard about in basements, broken down central air units, and intimidating measures alleged by a number of tenants. These same tenants said when they tried to get their units repaired, management was retaliatory in nature. If it had not been for the City of Topeka Housing Services, the fire department, and other staff in that first week, there would have been approximately 20 people, over half of these children, left homeless. HUD did not respond in a prompt fashion until they were pressed. Upon city request and supported by Representative Alcala, we had an emergency meeting the day of, I think it was the day it all blew open, or the next day, with the Kansas Housing Resource Corporation. In that meeting, KHRC basically pointed to all failures as being HUD. The reality is the ball was dropped by both of them. We then set course with HUD for a biweekly meeting with both entities and city staff. Ultimately, we had to engage Senator Jerry Moran's office, and thank you so much to Reed Petty, because information by HUD was held back and they were reticent in sharing. All this while the city was trying to decide how to manage what looked like and actually ended up being a housing emergency. As a city, we knew we had to change our position when it came to inspecting multifamily housing that received government funding. The City of Topeka, as with many municipalities across the state and country, are in a crunch with having enough decent, affordable housing. The passage of HB 2099 will give us the ability to keep a pulse, a more efficient and initiative-taking pulse on housing stock with interior inspections. It is not only beneficial for the tenant, but it is also for reducing costs to the city, since situations like the deep failures of Timberlea cost the taxpayer more than they should be expected to pay. This also leaves poor families in precarious positions. All the while, slumlords grabbing all the HUD, i.e. taxpayer, dollars they can without repercussion. And we know we cannot afford more homeless folks on the street, especially children. Once everything with Timberlea was exposed and the mandated HUD inspections actually occurred, the nail in the coffin was that Timberlea scored 0. And you could go from 0 to 100 after being inspected. Failure on every count for livable, safe, decent units. The owners of Timberlea were stripped of HUD's Housing Assistance Program contract. The owners of Timberlea were raking in, I thought I heard City Attorney say 800, but 80,000 a month is what they got while their tenants lived in squalor. What a slick setup. And I'm sure taxpayers feel the same. Please note, HUD and Timberlea have been in contract with each other since the mid-1980s. This is why I come to you today to please ask you to consider passing HB 2099 out of committee. I can seriously tell you, in the City of Topeka, we are doing so many things to try to raise the level of housing stock. This is one of them. Thank you.
Thank you, ma'am. We have one more oral proponent written, and that is Patrick DeLapp, citizen. Is Patrick here? Okay, we will put that down. Thank you, Patrick. All right. Is there any questions for any of the conferees that came up from the committee? Representative Blex.
Representative Alcala, I'm sorry, the city council, I apologize for that. I should have been more clear. Alcala, okay, well, if I butcher your name, I
No,
apologize.
no, that's okay. Valdivia Alcala, I carry my parents' name and my husband's.
And it sounds like there was a real tragedy here. HUD, do you know, was they required to make an inspection?
Yes, they were supposed to have annual inspections.
So we're going to pass another law to take up slack for people that didn't abide by the first law. And I guess maybe the chair is supposed to chastise, but I guess I'm going to exercise a little bit. I guess I resent being called a slumlord. I own 4 properties, and they're all in excellent shape, 2 in rural and 2 in city. And my tenants, I fix everything. But this bill, if we pass it, it'll apply to people like me versus your definition of slumlords that I don't like. And because I had an occasion where I rented to an Iraqi veteran. I'm a Vietnam veteran. I felt sorry for him. He had post-traumatic stress, moved into a nice 3-bedroom ranch out in the country. Long story short, he didn't pay rent. I was forced to evict him, go through the process, put up with a service dog that I really didn't want in there because of regulations. And I guess I would be part of this because the Kansas Housing Corporation, they got free legal services and put an extension. And in order for me to get my $6,000 back rent, I had to agree not to evict him, even though he hadn't paid me forever. And I'd been great, took his wife to dinner, mowed the yard, and yet I'm a slumlord. But, you know, I guess that kind of irritates me. And, you know, the fact that the landowners and property owners seem to have no rights. And this was expanded in COVID big time. So I guess this bill somewhat bothers me, and certainly the issues. And I'm not making an excuse for the tragedy that happened. Don't get me wrong. And I know there's people out there that don't. But for example, you said they was raking in 80,000. Do you know what their expenses was? I mean, I'm raking in quite a bit, but quite frankly, it's not very profitable.
Right. Well, a couple of things. This is only for Topeka. What this is HB 2099. And the other thing, when I reference, with all due respect, sir, when I reference the slumlord, everything that I talked about was talking about the experience of Timberley. And I do not take back those words because it is true. Do I believe that there are a wealth of good and decent landlords? Of course there are. We have Topeka Housing Authority. So this is not an either or. This is not extreme rhetoric. This is me telling you the experience, which was designated through all of my testimony, of Timberley. And they are slumlords. And they weren't putting anything into the upkeep. And they're located in New Jersey. And so again, HB 2099 is meant for Topeka only, sir.
Thank you. I have a follow-up with another.
Thank you, ma'am.
Thank you. Could somebody in the audience, either Amanda or Spencer, define home rule?
So a home rule.
That's the reason why I asked by name.
Well, I sure appreciate that. So a home rule in Kansas is the constitutional amendment that says if a law is not uniformly applicable to all cities, that a particular city could charter out of that particular provision.
Thank you. Then the definition of home rule has nothing to do with a landowner or a property owner that owns homes. As a home rule. I try to rule in my home. It doesn't work too well. My wife usually wins, but.
There you go. Just have your own home by me.
Well, that's what I was thinking. Thank you for that.
No problem.
I think one of the things I think is clear here is that because it's specifically targeted towards Topeka, others could apply to attach that to their own community, but it's not something they have to opt out of. It's something they would opt into as far as applying it to their community. Is that correct, Mr. Reviser?
Mr. Chairman, members of the committee, as the bill is currently written as introduced, it applies to any city or county that would not need to opt in or opt out. They could perform these inspections as the bill is currently written. If the committee were to amend the bill to make it specifically applicable only to the city of Topeka, then yes, other cities would need to pass charter ordinances in order to be able to act in the same manner as the city of Topeka and conduct inspections.
Thank you. Madam Minority Member. Sorry.
Thank you, Mr. Chair. Thank you, Representative Pishney. I know in this body, we don't like to get into issues that deal with only one place or get into the city's business. I also know that we are considered the option of last resort. Would one of the speakers from Topeka today like to speak to the last resort status of this?
Because of the current law in the books, we cannot do these periodic inspections. That's why we're here. We are happy to leave it uniform if you're worried about chartering or make it Topeka specific. We're very open to that. But we're here because we can't have these regular periodic inspections of these particular types of properties. And as has been said, we do have lots of really great landlords that we have really good partnerships. What we want is a tool for when we do run across these problem properties, that we have new ways to approach it.
Mr. Chairman, if I might just add a comment to that. You know, when this legislation was passed some years ago, it was in reaction to a municipality that was adopting an inspection program that had substantial fees applied to it. And so landlords, homeowners, there was some concern it could apply to residential properties and so forth. And so I mean, that's where the bill and the prohibition came from. It was a reaction to that. We certainly don't intend to apply fees and so forth to this process. I would also say that the city of Topeka has been involved with other bills in attempts to address some challenges that we have. Some of you may recall legislation on abandoned property. We recognize the Kansas legislature is very defensive of private property rights. And so that's why we've tried to craft a bill that is limited in nature. It is one in which a municipality, in this instance, the taxpayers, have a stake in this process because it's landlords, property owners that receive public money. And again, we've tried to focus it on the city of Topeka. So I just want to provide that for context. Thank you.
Thank you, Whitney.
Yes, thank you.
Representative Barth and Representative Pishney. Thank you.
I have a couple of questions, actually, and this could potentially be for Carrie or Amanda or Christina. I'm not sure yet. I think, you know, we definitely do not want to do something that penalizes the good guys that are out there trying to do a really good job, that are managing their properties. I think my very first comment I made asking the reviser about substantiation may be something that could really help, and I would be open to us looking at that so that it's not just a generalized random complaint. And I think the intent behind complaints is probably, even if one is substantiated, I would be open to that as well. When we look at what you guys shared with testimony, I mean, that's disgusting. I don't think anybody should have to live in that. If you are paying rent, indeed. If not, you should be evicted. But if you are having those poor conditions, I don't think that's right if you're a landlord. So my question is, the first question is, who owns most of these properties? Is it the same owner? Are we talking about, 20 different, is HUD the owner, or is there an actual separate entity that owns this property?
Yeah, Rhiannon Friedman, Planning and Development Director for the City of Topeka. So these properties are owned by various different companies. Most of them are from out of state. They generally own several properties like this across the country. Generally, that's what their portfolio is made up of. HUD manages the contract that gets them paid, their monthly payments. That's for the rent. but they own the property itself.
So they own the property themselves. When they're receiving these subsidies and these tenants that are receiving some sort of subsidy, we're talking about, private residential ownership. Is there anything that's keeping the landlords from selling it if they do not want to comply?
No, I think as long as they are able to, I'm sure there's a timing of their HAP contract with HUD, but as long as they break out of that contract, then they are still the owner of the property. I think what comes to a lot of concern with Timberley specifically is that this property started out in great condition, but then after several years without having any inspection is now a 0 out of 100. So I don't know who buys that property. I don't know if it's sellable. And without the assistance and the tenants being placed in there, I would imagine that they will be looking to get out of that situation.
Maybe think of a follow-up if you don't mind, Mr. Chair. So you're putting a little bit, this would put pressure on them fixing the problem and spending money. So, which obviously nobody wants to live in 6 inches of sewage, mold on your walls. I've seen the health effects that causes long-term to people. What if they just, would they have the ability to just say, I'm just not going to rent anymore, everybody's evicted? Like, how would that impact the lives of those people if that's the case?
Yeah, so what's interesting about this is, so Timberley specifically is project-based vouchers, which means that HUD has decided to put these vouchers that are tied specifically to the address to those units. So now that we found ourselves in this situation where the contract's being abated off the property, HUD has been working very closely with us due to a lot of the heightened level of concern that we were able to get across to them to provide emergency vouchers, which now allows these people that are living there to still be able to have vouchers in a one-time emergency situation to find housing elsewhere. It's unique because generally they were tied to that property. So we're also facing the fact that if that property goes away, we also lose 112 affordable housing units in Topeka, even though they're in deplorable condition.
Thank you.
Representative Pishney.
Thank you, Mr. Chair, and I don't know which conferee this would be these would be questions to, but the conversation that just took place segues into my questions. We're being asked to, first of all, address a city problem, one specific city problem, if the amendment would take place on this bill. Secondly, we're being asked to address a HUD problem that should be addressed through other venues. And so I'm concerned about our standing, so to speak, in addressing this problem. So it leads to my questions. If this is a HUD issue, it seems that Topeka would not be the only city experiencing this issue. And I heard, and somebody can correct me if I heard incorrectly, that HUD in its contracts has annual inspection requirements. So that's a two-part question. Were those annual inspections even taking place prior to this? And if not, why was HUD not engaged to amend those contracts if they were doing those, but that wasn't sufficient, I'm sorry, I misspoke. Why was there not a movement to have HUD amend those contracts to be semi-annual or quarterly? And then lastly to this, because it's all related to HUD, has Jerry Moran's office, Senator Moran's office, and I know Reed Petty very closely as a personal friend, or has Reed Petty been engaged to have HUD amend contracts? I understand you've got a current situation that needs to be fixed. I get that. And no, I would not go in and buy that property in the condition that you're explaining to me. But have we tried to work, first of all, with HUD as far as inspections and contracts and so forth, not just this current situation?
Sure, yeah, I'll do my best to answer that. So frankly, this has been a learning experience, I think, for all of us. So we're really taking this opportunity to dive deep to make sure that this doesn't happen again. Something that's unique about HUD for their project-based properties is They have placed Kansas Housing Resource Corporation, KHRC, to be the contract administrator, which means that they utilize KHRC at the state level to come in and inspect these properties. The state then reports it back to HUD, and then they report out the inspections that can be found in lists on their website. So prior to this, the last inspection that was done at Timberley was done in September of 2022, and the property scored a 60 out of 100. So the fact that in 2 years, the property went from a 60 at inspection completely to a 0 was shocking to us. And so COVID was the reason for the year skip, but the fact that the property was able to slide so much in condition during that amount of time is the concern. I'm sure this happens in other communities, but this was it's a unique situation for us, so we're trying to tackle it as best as possible.
And Mr. Chairman, and I don't know if this will end up being a question or not, but might be more of a comment, but my follow-up is this. Why would we not be addressing this as more of a statewide issue with regard to HUD projects? Because it doesn't sound like we're talking about other properties as far as the owners of other properties, other than the ones that are getting HUD assistance. Am I incorrect in that assumption?
I think that this bill is definitely framed around the federal assistance piece that's tied to the housing. That's correct.
So it appears that next year we're going to have someone else in or something else in with regard to this, and that's concerning to me. Thank you.
Thank you, ma'am, for your help. Any other questions for the conferees? Not seeing any at this point. Hey, hi, how are you?
Hi, Representative Carlin, in for Tobias, Representative Tobias. I'm just a little bit unclear and not having, it's been years since I was on city government, but as a former mayor, we had some issues in our community and we had various ways to take care of them, including getting the health department involved. But my question is, I know that HUD subsidizes the rent, and I'm hearing that they are supposed to communicate and inspect the properties at least once a year. But they don't, HUD doesn't pay for the repairs. I'd like to understand the process of the responsibility of HUD, and perhaps it might enlighten some of you on the committee, I don't know. So what is it that they are doing? And I also want to know kind of, maybe in that particular building, how much they're subsidizing the rent. If it's like an $800 apartment, what does the tenant have to pay?
Representative Conn, thank you for that. And would you state your name before you speak this time?
Sure, Rhiannon Friedman.
Okay.
Yep. I'm the
What is your role?
Yeah, I'm the Planning and Development Director for the City of Topeka, so I oversee the Housing Services Division.
Thank you.
Yeah, absolutely. So the way that I understand the process to work is that the contract is with the property owner, and it is to disperse monthly rent, right? So I believe the contract for the Housing Administrative Contract, HAP, for Timberley is roughly $90,000 a month that they are paid to the property, and that is specifically for rent payments. That is all that HUD pays. They're not paying for these fixes that need to be made to the property. I think that they make the assumption that the property owner looks at those rents and understands what their asset is and what they need to invest in it to maintain it. Sorry, you'll have to help me with the other part of your question.
Well, the responsibility of HUD is only to pay the landlord the rents and inspect. That, I just want to know the responsibility of HUD, because HUD's not going to come in and fix things, or HUD's not, well, if they found a bad inspection, what would they do?
Yeah, so it's their responsibility to ensure that through the inspections that the housing is safe and secure and that it's a livable condition. So that's why when they came back in for that inspection after the 2-year gap and saw it was a 0, that's why we're now at the point where they are abating the contract from the property.
Help.
Thank you, Mr. Chair. I hope that helped everyone. Thank you.
Yes. Representative Wolf.
Thank you, Chairman.
So when you say rent, does that also include utilities? Is that everything that is covered for the tenant?
Yes, so are the tenants responsible? 30%? Yeah, so the tenants are responsible for 30% of their utilities costs, but the rent is covered.
So HUD then also pays an additional 70%?
May I clarify?
If you can state your name, yeah.
Carrie Higgins with the Topeka Shawnee County Continuum of Care. So the tenants would pay 30% of their total income in rent, and utilities are factored into that allowance. So if they have no income, their rent would be zero, and they would receive a small utility allowance. If they do have income, they're going to pay 30% of that towards their rent.
So this amount that they receive is for utilities and rent that Kimberly or whomever is going to receive?
Yes, it may not cover the utilities in full, but it gives each tenant a utility allowance.
Thank you, committee, and I will open opportunity for anyone in the room that would also like to speak as a proponent that did not sign up. Is there anyone else that wants to speak as a proponent? Not seeing any. We'll move on to oral for opponent. There is no neutral. Is there any neutral testimony that anyone would like to share? Any neutral on this issue as a material witness or anything else? Okay. Not seeing any. For opponent, we have, starting with Ed Jaskina. Jaskina. Okay. Ed, thanks for coming to committee.
Thank you. Appreciate it. I know we're in negative time now, so I'll try to be brief. If you want to know what I was on this thing, I think it's one of my better written things. It explains the background of how we got here. And how we got here was not about fees. It was about the extreme abuse of interior inspections by certain cities, not Topeka. Topeka wasn't bad from what I hear. But certain cities were just doing routine inspections. Tenants were begging us to do something to stop people coming in without their permission. It was a Fourth Amendment thing. We put up with it for a long time, and in 2016, it got so bad that we introduced a bill that would prohibit the cities from doing routine inspections without the lawful occupant's permission. And we put lawful occupant instead of tenant because it seemed to make more sense. The tenant is the only one that has the right to allow the inspection. The landlord nor the city can retaliate against the tenant or the lawful occupant for saying yes or no. When we say that, I'm going to put this proper way here, the tenant has certain rights, but they've also got certain responsibilities with those rights. And the responsibility is if there's a life safety or health issue, they need to say something. They're affecting their family, they're affecting the other people in the complex, if there's a complex. I empathize with Topeka. I mean, I really do. I understand. I know you object to the term slumlord, but there are slumlords out there, and I'm not a representative of one of those. I'm a representative of the good people. And we hate slumlords, but we also hate, in this particular case, Section 8 not doing their job. And Section 8 is where we need to deal with this. Not have heard, but a couple weeks ago, we got an administration in Washington, D.C. that seems to say we're not going to put up with people not doing their jobs anymore. And they're going after government entities that are not doing the right things. And that may be a place to start, is to get them involved in it. We have to protect the rights of the tenant. And somebody asked me during the hearings in 2016, they said, you represent landlords. Why are you trying to protect the tenant's rights? This is because we're all available. We all need to have our rights protected. And he kept pursuing this, and I says, okay, I says, what happens if the city comes in and says, you're an owner-occupant, we think there's problems in your house. To protect you, we're going to come in and inspect your property. And he says, well, we've got guns. We can stop that. And I says, well, why shouldn't the tenant have the same right? Why shouldn't they be protected in their rights? I want safe and affordable housing. But in this particular case, they say it's Topeka only, it's not. You can opt out of it, whatever. I've talked to Whitney, I've talked to Amanda. I will be glad to help find a way to do this in a manner that's not doing it this way. I don't know that there is a way. I really don't. I thought I found a way yesterday, but it was wrong. But I would encourage you to ask them to, let's pursue this a different way if we can. This is not a good bill. And I would encourage you to read this.
Ed, we'll hear one more opposition testimony, and then we'll take questions. Patrick Delap, citizen, would you come to the microphone, please? And thank you for being here.
I'm a landlord too. I'm also an officer of a neighborhood improvement association. I do not support this at all. What you're being told here is not the unvarnished truth of what happened. When I heard about this, I went down there because I thought it was strange. Immediately, these people with the sewage, things like this, got help from the city, payment, hotel rooms, things like this. We haven't done that in 35 years. What's up with that? So I started looking around, asking questions, talking to one of the occupants too. One of the occupants did not get relocated to a hotel room, instead got moved over to another unit in the facility, which was fine. She was telling me, yeah, after the sewage shows up, the city water department was over here pulling sewer lines up and down, things like this, looking for problems. And then this occurred October 6th. By October 7th or so, people were, they were staging for opening cleaning lines. What the fire department found, and I've got the official report right here, was not levels as high as 600. And it's not parts per minute, it's parts per million of carbon monoxide in it. What they found in there was, and it varied from upstairs to downstairs, like 250, 200. Two of the units were even below the threshold at 18, 9, and 7. But they did have readable levels. Now, your carbon monoxide, which are required if the inspection is done and by the two inspection things we have, are carbon monoxide detectors. Those carbon monoxide detectors set off anywhere between 30 and 70 parts per million, and it is on a time base too. Just because you have a flash of a high carbon monoxide doesn't go off, because that's how carbon monoxide gets you. It's over the time period. OSHA, NIOSHA even have regulations that you can be in a certain environment with this high of a level of parts per million for so many hours, then you have to leave. All the units at the dryer vents did show high carbon monoxide levels coming out. Why that is, you would think the dryer vents wouldn't be interchanged. Well, it was. I can't explain that at all. Now, to continue with this, what was later learned is a sewer line had collapsed a block up, approximately 208 Lime, and these projects are 300 blocks of Lime. Apparently back about 10 months previous, in December 2003, a sewer contractor was doing work. I'm getting this information from what the excavation contractor was for. You know, they were working throughout the night for several nights on that in City of Topeka, and I've got pictures of the day activities and night activities.
I'd like to interrupt you just for a second. Are you opposed to inspections in general, or are you analyzing just this particular case?
Inspections in general, especially for this, because HUD does not want the cities getting involved in their territory, readings and beatings. The cities will be doing things that they don't consider safety and health, making the, more landlords dropped out of the program. Between 2010 and 2020, over 50,000 people had left the program because it was just too difficult to work with. How was it difficult to work with? Is the timeline for having your units inspected and then finally getting approval. Best case scenario, if there's no failure, it's 3 to 4 weeks. If you had a failure, well, can't move in, they got to go up, then we're talking about 7, 8 weeks. And you might have another person willing to come in. So HUD wants to streamline the process. They streamline the process from changing from HQS, Housing Qualified Standards, to Inspire. Now, what they found, the city was the reason the sewer line was backing up. They had failed to maintain the line. The management of the company had that cleaned out 3 or 4 times, but it kept coming back. What they found is this sewer contractor, which was replacing for a private individual, couldn't get down to the 21 feet that the sewer line's down. It's deep. City code does say.
I'm going to interrupt you just one more time. You're stating some things as fact.
Yes.
And you gathered these piece of information from somebody else. I just want, for your own sake, I hope you'll be careful not to make accusations of who's responsible for what if you're not the one that's the expert to do. All right?
I was going to use the word
Thank you.
alleged with the contractor. So I'll say a contractor did this with the sewer line back in 2000. He couldn't get down that deep. City code does say if the sewer line is extra deep, we may help you with the cost of getting down that deep. This has to do with the flooding of it. So basically, the sewer was backing up from the city's problem. The owner made the mistake of not screaming at the city. Now, getting back to housing quality standards. The inspection process, the current code says right now they can't force their way in with a warrant. And they don't want them to come in because they don't want things written up that's going to deter landlords from working with that program. It's a good program. Here are some things in the program that they will be looking for. And keep in your mind, think to yourself, does your own house you're living in have these things? Every place with your 6 feet of a water line, you have to have a GFI. Kitchen, bathroom, your washer even must now be GFI protected. Smoke detectors are now required in the new Inspire code.
I'm going to ask you to wrap your comments up because you're going a number of different directions, and we do want to get to the subject of this particular bill. And I appreciate your testimony, but if you'll wrap it up.
This bill letting the city in, they will inspect things that are not at all that HUD once inspected. Landlords will be penalized because right now, if you have a violation, it's $499 in jail, or $499 fine, or 6 months in jail. Last week, January 1st, we even had a memo come down that because of the city budget, any violation of public safe and healthy code will be prosecuted. Before, if you had a timeline to fix it up, you can tell that timeline, but we're still going to prosecute you. Why? Anytime we prosecute, you got to pay $75 even if we dismiss it. The only way to get rid of that $75 is go through a full trial and the judge says not guilty. I don't support this. This is going to reduce the amount of landlords wanting to participate in the program.
Thank you, kind sir. Are there any questions for either of the two opponent conferees? Okay. Representative Essex.
Thank you, Mr. Chair. Very interesting conversation. I appreciate hearing from both sides. I just want to share with my experience that when we have problems with HUD housing, apartment, personal, private property, when the air conditioner goes out, the city hears about it. When there's flooding and problems, the city hears about it. We're the ones that get those emails. And I will share, unless it's complaint driven, the city is not always, they don't understand those conditions. And I guess my question would be for Ed. I know you mentioned that we need lawful occupants permission to be able to do these inspections. I would say a lot of times in these situations, they're embarrassed to let someone in their place. They don't really want, just because of embarrassment of the conditions of maybe of where they're living. How do we get their permission if we know there's a problem? How do we help them?
Says, as we wrote it in 2016, that all I have to do is ask. And you can ask them, I'm sorry, you can ask them for permission, and that's what the city's been doing. If somebody doesn't want you in their house, there's no way to force them unless it's an administrative search warrant. And those judges are hesitant to offer those sometimes. But if it's a life, safety, and health issue, you've got to do what you got to do. To your question, how do you know that they've got a problem in there if they're not the ones complaining?
Neighbors, people that are around them, people that experience other people coming in and out of there. There's a lot of people that can witness a problem outside of that person that's living in that condition.
Wouldn't that be grounds to get a search warrant, though, if there's enough people complaining that there's a problem? I mean, if you smelled a dead body in a place, wouldn't you be going in there for that? So if you're smelling sewage, that's a life, safety, and health issue.
All right. Yes, ma'am. Well,
Dead body, yes, that would be a warrant. I would say outside of my air conditioning won't work and I can't get anybody to fix it, a lot of cities have people that go over and assist with that and help with that. Not everything is warrant-based, no. Concern-based, maybe. So I don't know, just some thoughts of my experience with these types of situations, but I appreciate your answers. Thank you.
I agree with you. And like I said, I empathize with the city, but we've got to protect the rights of the whole in the process. So if we can find a way to do it where it doesn't affect that, I'd be all for it. So.
thank you, Ed. Someone else? Not seeing any from the committee. Is there any other comments to be shared before we close this hearing on opponent or proponent? You may. Please come to the microphone and state your name.
John Alcala, 57th District Representative. You're exactly correct. I didn't put that in my testimony. Several houses we went to, the lady let us in, but she said, excuse the house. And my God, there was magazines, clothes. There was a pathway to the kitchen, and she was real embarrassed. She was so embarrassed she was in tears. I didn't put that in there, but that was a fact. And so, and I wanted to address Representative's question about being for everyone. Actually, what happened was when we met with Mike, there was a misunderstanding. This bill was supposed to be Topeka only and not wide. And anybody that, in other municipalities that wanted to get on board, they could, or they'd have to go through a process within their municipality to get on board, because some people don't want this in their areas. And the other comment that was made, that why are we doing it for Topeka only? We do it all the time. Johnson County, Western Kansas. Sometimes when there's no other options and we've eliminated all the due process, it leaves us no other option than come back to the state.
Thank you, Representative.
Thank you.
All right, we're down to the end of this testimony on HB 2099. So I will close the hearing on 2099, and we will begin. If is anybody on a time restraint where we can't start another hearing? Good, because we're going to start one. HB 2116. Mr. Revisor, if you'd please give us a brief.
Thank you, Mr. Chairman, members of the committee. House Bill 2116 is a bill that this committee saw last year, creating new statutes to require certain cities and counties to use standard contract provisions prescribed by the Department of Administration that are used in state contracts. These contract provisions are generally contained in a form that's issued by the department and apply to governing warranties, liabilities, taxes, insurance, and applicable laws and governments of these municipalities. These provisions will be required to be included in each contract unless the governing body decides to omit a provision. There are, however, some that cannot be omitted. Those are in sections 2, 3, and 4, 2 and 3 of the bill relating to assuming responsibility for actions and conduct of other parties, and the jurisdiction for disputes over the contracts being the state of Kansas. I will point out section 4 is new to the bill this year and limits the scope of the bill. It is on page 2 of the bill, line 34, so that these provisions would only apply to cities of the second or third class and to any county with a population of less than 35,000 people. So it's looking at smaller cities and smaller counties in terms of the application, not your big metropolitan areas. The bill would go into effect on July 1st of this year and be applicable, and I'll be happy to stand for any questions.
Questions to begin with for a reviser? Not seeing any. Thank you, Jason. We have proponent testimony written only by Jeff Chubb, City of Independence, and Jay Hall, Association of Counties. Is there any testimony in person that would like to be given in as a proponent to this bill? Okay, we've got a comment from the chair.
Thank you, Mr. Chair. As most of you on the committee, I introduced this bill last year. It was House Bill 2537, and we had some of the first-class cities didn't really like some of the provisions. Those, I believe, have been changed, and this was introduced by our city attorney, Jeff Chubb at Independence, that basically wanted a contract attachment that would simplify their world and make things a little non-binding and with the vendors and, you know, provide some indemnity. So I completely support it. You know, I testified for it last year, and our city, it's real important to them. So I'd appreciate your support on that.
Thank you, sir. Is there any other proponent testimony? Not seeing any. We'll move on to neutral. We have one oral, John Goodyear, League of Kansas Municipalities. And thank you, John.
I'm not John Goodyear. I am Spencer Duncan with the League of Kansas Municipalities, because John is home iced in. So he is the attorney, and usually we like to send the attorneys for this stuff. I'm the son of an attorney, but I'm told that's not the same, so I don't get to pretend to be one, but you get me anyway, and I'll do my best. We're neutral on this, but we do support it overall, and I want everyone to understand a few things. All the people who will be impacted in this have been at the table and part of this conversation. The cities who are impacted of every class, first, second, and third, have had input into it. We talked to Representative-elects last year and over this year to be able to see versions of it. Attorneys have looked at it. So anyone who's going to be impacted has had a chance to weigh in on this, which is why the language in front of you separates the difference between the first and then the second and third class cities. And a lot of that comes down to second and third class cities, for right or wrong, just don't have the same sway when they're negotiating with certain groups that first class cities have because of their size and their capacity to do certain things. And so for those first class cities, attorneys can make different deals sometimes. And the second and third class cities absolutely would appreciate having these and being able to just put them in contracts. So we've worked on that. That's the tweak to this. So really we're neutral in the sense that as long as you don't change a word of this bill that we've all worked hard to get to this point, we're great with it. And so that's why we're neutral in that sense. Don't change it, and then we won't have to, we're all fine with it. So there's the very short version of my testimony, Chair.
Good job, John, or whoever you happen to be. All right, and we have no more neutral testimony. Is there anyone that would like to testify neutral? Is there anyone who has opposition that would like to testify? Please get in line. There is none. So I will close this hearing on House Bill 2116, and we will likely consider this at a time near in the future. I want to let the committee know that I have asked the Speaker of the House to allow us to have an interim committee on House Bill 2025. One we heard last week. There's been a lot of interest and a lot of issues yet to iron out amongst the parties that are involved. And he has consented to that, so we will plan on an interim committee. And if you want to be part of that committee, let us know. So we'll have just a few from both the Senate and the House, because they are asking the same thing. We'll have a joint committee if we can. And so in that regard, that issue is not blanked out. It's just set aside for, and keep in mind that in a biennium, we have a bill for 2 years. So as we heard with Representative Blex's comments about the bill we just dealt with, the amount of time that for other parties to come together and work things out made things better, and it didn't have to be hammered out in the first meeting. So we'll see how that goes. So I will ask if you would, if you've looked at the minutes for January the 22nd, 27th, and 29th. If you have, is there someone that would make a motion to approve? Got a motion to approve. Is there a second? There's a second from Representative Essex. If all in favor, please say aye. All opposed? And we have minutes for all of January. We will have an agenda posted by the end of the week here, probably in the next day or so, or next week, but it should be some busyness. So thank you, and this meeting is adjourned. Have a great day.